Thanks everyone for joining us today. My name is Rebecca Stevens and I'm here with my colleague Jaya Bajaj. We are both associates in the employment practice group at Farella, and we're here to talk to you guys today about all the employment law updates and the issues that are rapidly changing as the current new normal continues to evolve. So we're excited to be here and we're excited to talk to you all about this important and ever-changing topic. So just a quick overview of the topics that we'll be covering today. Obviously one of the main topics on everyone's mind is how to safely return employees to work if you are having employees return to an office or a work site. We'll also be covering issues related to employees who are continuing to work remotely. Some employee and privacy and medical issues related to the COVID-19 pandemic, complying with EEO obligations in the COVID era. There are a lot of issues that have come up under this umbrella, so we'll be covering some of those. And then we'll be talking about how to manage employees' time off options, including sick leave, vacation, etc., and how all of that will interplay with the pandemic and working from home and all the rest. And as Margaret mentioned, we'll have time for questions at the end. So if you do have any questions, feel free to submit them in the chat, or you can just hold them until the end of the presentation and we can talk about them later. So the first topic, safely returning employees to work. This is a complicated, ever-evolving area. Lots of new guidance coming out all the time, lots of different sources of information. So lots to keep track of here. If you are considering bringing employees back to work, to an office or any kind of a work site, make sure you review all of the relevant public health orders for the specific requirements. We do have a lot of different sources of information. Some of them are consistent with each other, some of them conflict with each other, so it's important to make sure you're aware of all the different rules and all the guidance. So, the state of California, as you know, has repeatedly come out with public health orders. Governor Newsom has issued executive orders on this issue. We've also got OSHA, so the California state version of OSHA, which tends to have a little stricter and more detailed requirements than the federal OSHA. That being said, the federal agencies, OSHA and the CDC, are also putting out guidance on this issue. And lastly, any city or county where you have operations or employees, you'll have to review the local orders there too. So a lot to keep track of. And in general, if you're finding that any of these orders conflict with each other, you'll need to follow the one that is the most conservative approach. So OSHA has been pretty regularly updating its guidance, putting things out on the website. For starters, as you probably all know, California employers have long been required to have an injury and illness prevention program to protect employees from hazards, and that includes disease. And for any employer with a workplace where COVID-19 may present a hazard to employees, employers will need to update their injury and illness prevention program to address COVID-19 related measures, and also put in place additional safety measures for employees to follow if they are coming to work. The guidance from OSHA is that most California workplaces are going to be required to update their injury and illness prevention program because COVID-19 is so widespread in California and is a risk in probably all workplaces across the state. So these are some of the requirements that OSHA has put out in terms of updating your injury and illness prevention program. You'll need to encourage any sick employees to stay home. If you have employees that are coming into work with symptoms, they need to be immediately sent home. Employers are also required to provide expanded paid sick leave or expanded family and medical leave for COVID-19 related reasons, which we'll cover a little bit later what some of the new requirements are with that. If you have any employees that have been diagnosed with COVID-19 and are now returning to work after recovering, those employees need to immediately report any recurrence of symptoms. So if it seems like they're better, but they're starting to experience symptoms again, they would need to report that. The guidance is still that employees should telework when possible. So if it's possible for your employees to work from home, that is still the best practice, and that is still the guidance that Cal OSHA is putting out. If you do have people coming into an office, you need to make sure that they're practicing physical distancing, that they are wearing cloth face coverings at all times when they're in the office. You should avoid any shared workspaces. So a lot of employers in the last several years have moved to these kind of open floor plan, shared workspace approaches where everyone's kind of in a common area. And that's not going to fly right now with the pandemic that's going on. So if you do have that kind of a floor plan, you'll need to come up with alternatives for that. There are increased cleaning and disinfecting requirements, so making sure that we're stepping up in that area. And then finally, discouraging any travel, and any work-related travel would be covered by that as well. Cal OSHA has also put out a lot of industry-specific guidance related to COVID-19 and safety measures. We're not going to go through all of these in detail. Many of them don't apply to you guys that are on the call, but just keep in mind that aside from the general guidance that we just covered, if you do have any operations that fall under these industries, there are additional, more detailed guidelines that you need to consider. So in addition, for anyone that's located in the city of San Francisco, as you probably know, San Francisco employers are required to prepare, post, and follow a social distancing protocol at every active facility. So that includes a lot of the same things that Cal OSHA is recommending. So encouraging employees to stay home if they're sick, making sure employees know under what circumstances they should stay home. So specifically identifying the symptoms that would require an employee to stay home from work. You do have to have a plan in place to keep the site personnel safe, which includes limiting the number of personnel and customers that are coming on site and continuing to encourage people to work from home. You'll need to put in place measures to prevent unnecessary contact. And so that's a lot of the stuff that we've been talking about the whole time, making sure that people stay 6 feet apart at all times, that work areas are separated by at least 6 feet. If you have anywhere where people are lining up, you'll have to have markings in the line areas showing how far apart the people in line need to stand. And ensuring that any high touch areas are frequently sanitized and kept clean. In addition, you'll have to post some signs about the social distancing protocol, and there may be, just as with Cal OSHA, other industry-specific requirements depending on what your operations entail. Speaking of industry-specific guidelines, these are the industries for which San Francisco has issued specific guidance. So if you do have any operations that fall under these categories, then you'll need to look at the specific guidance that's in place for that industry. So in general, what we've been advising for all employers, regardless of industry and regardless of how you're continuing to operate, we do suggest that all employers issue some new temporary policies, temporary protocols for all employees about what safety measures you're putting in place during the pandemic. And so some things to think about as you're developing those guidelines are, how will you deal with common areas? If you do have people that are coming into an office for some reason, what are the rules and requirements around common spaces that people might share, which could be a place where if somebody came in and was infected with COVID-19, they'd be more likely to spread it to somebody else. So, restrooms, kitchens, conference rooms, what are you putting in place around those areas to make sure that people stay safe? In addition, physical distancing is really the key, making sure that people stay, at least 6 feet apart, shouldn't have any kind of group gatherings or in-person meetings, especially not in small enclosed spaces. Also, if you're working in a building that has elevators and stairwells, what are you doing to keep those spaces clean? Who's responsible for sanitizing elevator buttons or doorknobs, things like that? What are you doing to limit the amount of high touch, high contact areas that people could be spreading symptoms or germs? If you do have open office space, again, the best guidance that's out there is to try to put up physical barriers, or maybe have some kind of a rotation system where you don't have everybody coming in at the same time. Small groups of employees can come in as long as they're staying far apart and they're following all the other rules. Personal protective equipment, depending on the type of work that you're doing and how much interaction it involves with other people, you may need more personal protective equipment than some other employers might need. But in general, everyone should be wearing a cloth face covering at all times while in the office. Probably you'll want to reduce the maximum capacity of various areas in your office space if you do have people coming in. And then again, with work-related travel, it should really be discouraged. And if you do have employees that are really required to travel for some reason, you'll probably want to put in place some kind of a temporary policy dealing with that issue as well. The CDC has also put out Return-to-Work Guidance. And it's, a lot of the same stuff that we've already talked about, but some other interesting aspects, daily health checks for employees that are coming back. So, if you do have people coming into a building, are you going to implement temperature checks? Are you going to have people take their own temperature at home before they come in and certify that it's below a certain number? Are you going to be checking people's temperatures at the door? All of these are things that you'll have to think about. Face coverings, again, really important. The CDC has been increasingly focused on building ventilation, making sure that there is adequate ventilation in office spaces, that the air is circulating, and that all of that is in working order. As we learn more about COVID-19, it seems like it's more airborne than people initially thought. So the CDC has been really focusing on this ventilation issue, and you may want to check with your building maintenance staff just to see what's being done in that regard. Again, with physical distancing, a key component, making sure people stay 6 feet apart, frequent hand washing and cleaning, making sure you're educating employees on how to protect themselves, modifying office layouts, staggering shifts. So making sure that if you do have people come back, your whole office isn't back at the same time. Maybe half of the office comes back for 1 week, and then the other half comes back the next week, and they kind of rotate like that. That's a solution that we've seen some employers doing. Making sure you have signs up. They're also recommending that there's a designated point of contact for all COVID-19 questions and issues. So if you have someone that kind of deals with safety issues or someone in HR, that might be the right person to handle the COVID-19 issues. And then again, the flexible sick leave policies, which we'll get to later. But in general, the main thing to think about, there's so much information, there's so many guidelines, there's so many requirements, but from a big picture standpoint, really think about how are you going to get this information to your employees? How are you going to make sure that they understand what the expectations are? What are you doing to reinforce all of these different safety requirements? And a lot of that has to do with communication, training, and just consistent application of these policies. So that's what to think about. So, for those of you who are feeling really overwhelmed by all of these guidelines, feeling like there's just so much to keep track of, or for those of you who are really itching to bring people back early, you're tired of the work from home, you really want people back in the office, keep in mind that bringing people back too soon or not having adequate safety measures in place for your workers can lead to a variety of potential liability risks. So the first one, workers' compensation. Anyone that gets sick at work with COVID-19, as you may have read, there is now a presumption in California that if someone's been coming to work and they get COVID-19, there's a presumption that they caught it at work and they're entitled to workers' compensation, which would cover the medical treatment for COVID. It is a rebuttable presumption. So if you're able to show that, for example, no one else in your facility had it and you followed all the safety measures, you may be able to overcome that presumption. But keep in mind that, that's a big risk for a lot of employers. If you aren't following the safety protocols and sort of the best practices that have been put in place, OSHA, of course, has the capacity to investigate and bring enforcement actions against any employer that's not following the safety guidelines. So if you are going to have people coming into an office or a work site, you need to make sure that you're following OSHA's best practices, or else you may have them, knocking on the door. And increasingly, we've been seeing a lot of plaintiffs' attorneys advertising that they're planning to bring lawsuits against employers on a variety of different legal theories, including whistleblower retaliation. So if you have an employee who has, raised concerns about safety practices, raised a complaint that they don't feel like it's safe to come back, and you're forcing them to come in, or you're firing them because they don't want to come in, that could lead to some kind of a whistleblower retaliation claim. In addition, we've already seen a variety of wrongful termination lawsuits that have been filed related to COVID-19 for employees who claim that they were terminated for refusing to come into the office, asking why there wasn't sufficient personal protective equipment in the office, or raising concerns about people not wearing masks, or people who were expressing concern that other employees seem to be coming in with symptoms. So these are all things, if somebody's raising concerns about COVID-19 and they're refusing to come back because they don't think it's safe, and you're thinking about terminating them, think very carefully, because you may find yourself subject to one of these lawsuits. Lastly, one of the more interesting theories that we've seen certainly being pushed by plaintiff side attorneys is the theory of constructive discharge, that if you don't make the workplace safe enough, if you're not putting in place enough safety measures, if you're not allowing people to work from home when the nature of their work means that they probably can, the employee may feel like they have no other choice but to quit, and then they could bring a constructive discharge claim against the employer. So that's kind of an interesting one, and obviously a novel theory. So we'll have to see how that plays out in the courts. The big question that's on everybody's mind is, what should an employer do if the employees don't want to return to work? So let's say you've put in place all of the different safety measures, you're following the guidance, you've come up with all these great new policies to ensure that everyone is safe to come in, and you still have employees saying that they don't feel comfortable coming back to a work site. What should you do? As a quick aside, I will say that within the last couple of weeks, I sat through a presentation from the regional director of the EEOC, as well as a regional director from the Department of Labor, and even they didn't really know exactly all the answers to this question. So it's remaining an evolving issue. There aren't really any clear guidelines out there yet, but just a couple of things to keep in mind. If you do have employees that don't want to come back in, your first step should be to confirm whether there's any way the employee can continue to do their work from home. And we often hear from employers that they're worried that employees aren't as productive at home, or they're not able to do the same type of work that they were doing in the office, or the same quality of work. But the guidance from all of the agencies still today is that, to the extent possible, everyone should be working remotely and working from home. So you should really think carefully about whether it's possible to have your employees working at home either full-time or the majority of the time. Secondly, you should determine whether any employee that doesn't want to return is entitled to a reasonable accommodation. So if you have an employee that's saying, I really don't want to come in because I have an underlying medical condition and it makes me especially vulnerable to COVID-19, that employee may be entitled to reasonable accommodation under either the ADA or California law, and a reasonable accommodation could include either allowing them to telework or allowing them to take a leave of absence until they're able to come back in. So make sure that you've kind of checked that box before you move forward if somebody's saying they don't want to come in. You'll also want to consider whether the employee is eligible for paid sick leave or the new federal leave, which we'll cover towards the end of the presentation. Both San Francisco and the federal government have now, come out with new requirements for paid leave for employees for reasons that are related to COVID-19. And so you may have employees that have some sort of a qualifying reason that would entitle them to this leave. And if so, you need to make sure that it's being provided to them, and you shouldn't move forward with any kind of adverse action if they are eligible for that leave. The other kind of interesting piece of this is, if an employee is refusing to return to work, it's possible that they may still be eligible for unemployment. So the EDD has actually issued guidance saying that even if the employer is offering work to the employee and allowing them to return to work and saying that they can come in and there's work for them to do, the employee could still be eligible for unemployment if the position is determined to be unsuitable. And that includes if the employee is over 65, if the job is not in an essential sector, or the employer hasn't met the reopening requirements, or if the employee has a weakened immune system or some kind of underlying health condition. So even if the employee is the one that's refusing to return, it is possible that they could apply for unemployment and the state might give it to them. But if you do find yourself in that situation where you've offered work to somebody, offered to bring them back and they're refusing to come in, make sure that as the employer, you're notifying the EDD that the employee actually did have work that was offered, but they turned it down. Okay, Jay, I'll turn it over to you.
Thanks, Rebecca. So as Rebecca just went over, a lot of the guidance that's coming out of the CDC, the state, locally, is that employers should be encouraging remote work wherever it's still possible. So obviously that still raises a lot of questions for employers on what the implications of remote work are and what some of the best practices should be. So we're going to briefly go over a couple of those. Next slide. So one of the big first things to keep in mind is even if your employees are working remote, they're still subject to the same wage and hour obligations that they would be subject to on site. So for exempt employees, that means that they need to be paid their full salary for any week that they're performing work. For non-exempt employees, that means that they're paid for all time that they're reporting that they're working. So even though they're not physically reporting to the site, you don't see them working. If they're reporting that they're logging on to work, logging off, they need to be paid for all those hours that they're logging. And also with non-exempt employees, one of the more tricky things to keep in mind is that meal and rest break requirements still apply. So one of the second things to keep in mind is expense reimbursement. So employers, even though employees are working from home, are still entitled to reimburse them for some reasonable expenses that they incur in furtherance of their work-related duties. So that could include things like setting up a more ergonomic workspace. That could be something, on a case-by-case basis that employers are obligated to reimburse their employees for. Next, there's still workers' compensation obligations, even though employees are at home. So just like employers are obligated to create a safe work environment when employers are reporting on-site, they may still have certain duties to do so when employees are working from home. And similar to that point, employers are still entitled to provide reasonable accommodations where it's possible. So if an employee with disabilities needs an accommodation to telework, similar to what they needed as a work at their physical work site, such as a more ergonomic workspace, the employer should provide it unless it would be an undue hardship to the business to provide that accommodation.
Yeah, one thing I'll just add here on the workers' compensation front, which is kind of connected to this, going back to the ergonomic workstation, I think a lot of employers are kind of shocked to hear that they may be required to purchase an ergonomic chair or an ergonomic desk or something that would help the employee work comfortably from home. But we have been hearing from clients that they're kind of starting, now that we're going into 3 and 4 months of people working remotely, that they're starting to get these workers' compensation claims from employees that have been working from home saying that they're getting back pain, neck pain, wrist pain from sitting at a non-ergonomic workstation. So even though it seems like it's kind of an unreasonable cost that you might have to provide somebody a desk for their home, keep in mind that if they are kind of developing these injuries and these health conditions from not having the right setup, that's a place where the employer may face liability as well. The other thing that we're seeing a lot with expense reimbursement is the cost of internet. So, a couple years ago, you may recall there were a bunch of cases around reimbursing employees for their cell phones. Employees that were, using cell phones mostly for personal purposes, but also in some sense for a work purpose. The courts were coming out and saying that the employer may not be required to pay the employee's full cell phone bill, but would have to pay a portion if they're using the cell phone for work purposes. I think the same reasoning is probably going to apply to home internet. So just keep in mind that, there may be obligations coming up for additional reimbursements that weren't necessary before.
Another thing to keep in mind, and this applies to both employees returning to work, or mostly to employees who are going to be returning to work, is that there's a whole host of unique privacy and medical issues that have come up in the COVID-19 era, which we'll start to go through in turn. So as many of you may know, federal authorities, the Americans with Disabilities Act, and analogous state authorities typically restrict employers on what sort of questions they can ask their employees about their health conditions and any disabilities that they have. Here, given COVID-19, the EEOC and the DFEH, which is the California Department of Fair Employment and Housing, have issued specific guidance that sort of broaden the questions that employers are permitted to ask their employees when it comes to COVID-19 related symptoms or issues. So employers are now permitted to ask about employee symptoms, although any information that they receive still must be maintained as a confidential record. They are allowed to take temperatures of employees to evaluate risk in returning them to work. They're allowed to ask their employees why they were absent from work. And if the employees have been absent from work, they're allowed to require a certificate of fitness for that employee to return to work. All that being said, our suggestion is that employers continue to rely on judgment and recommendations that they may receive from health professionals regarding medical documentation. In some cases, it may even be beneficial to waive documentation requirements for COVID-19 related disabilities, just because it's difficult in a lot of areas for employees to get tests, to see a doctor. So if they're reporting symptoms, generally the suggestion is that you don't force them to prove that they may have COVID-19 or COVID-19 related symptoms. But just one thing to keep in mind there is that that documentation may be required for later tax refunds. But in general, just in order to proceed safely and not return an employee who may actively have symptoms to work, we suggest loosening those requirements to bring in medical documentation. Next slide. So in addition to that, mandatory medical testing is permitted, although it must be job related and consistent with business necessity. And employers should also take steps to ensure that any tests that they're requiring are accurate and reliable. And for that, you can rely on guidance that's been issued by the CDC and the FDA. So sort of separate from the classic COVID-19 testing is the new antibody testing, which there's been a lot of controversy about because there are questions about the accuracy of it. So while the EEOC and the DFEH regulations currently do allow for testing of a current COVID-19 diagnosis, employers should avoid antibody testing. So that would be a test that evaluates whether an employee may have had COVID-19 in the past, in comparison to a COVID-19 diagnosis, which evaluates whether an employee is currently safe to be around others in the workplace. And the reason for that is there has been guidance issued by those authorities suggesting that an antibody test may be an unlawful inquiry into an employee's medical history rather than their current status and ability to return to work. So if you learn that one of your employees has contracted COVID-19, you can notify the workforce of their potential exposure risks, but you cannot notify them or reveal names of who those impacted employees or employee was. So the DFEH has issued some suggested language on how employers can notify their workforce of a potential exposure risk, which we've included here. Essentially, it states that an employee, without identifying that employee by name, has tested positive for COVID-19, and when they receive those test results, it's meant to be a notification that they may have been potentially exposed and that they should contact their local health department for guidance. So it's fairly vague, but does satisfy the understandable desire that many employers will have to notify their employees that they may have been exposed at the workplace. So many of you may be considering requiring the use of contract tracing apps by your employees. This, again, is a very controversial issue because of the various privacy and morale concerns that go into requiring your employees to use such an application. So we suggest there's a lot of communication to employees about the scope and the purpose of an app, and a deep consideration on whether that should be a voluntary application that employees can choose to use, or whether it's mandatory. In either stance, we suggest that all employers receive consent from their employees before issuing any such requirement to download a contract tracing app or send data from such an app to the employer. There are also a lot of collective bargaining requirements that come into play here. So there may be explicit contractual provisions if you have any employees that are subject to a collective bargaining agreement that limit the use of such apps. So certainly there are a lot of things to keep in mind before implementing a contract tracing app policy in the workplace. One of the biggest things is the privacy concerns with the issuance of such apps. All the information collected by contract tracing apps are confidential medical records. So for employers that are covered by the California Consumer Privacy Act, that means that you have to provide notice to your employees before any information is collected. And it sort of goes to understanding the full gamut of data that's being collected. A lot of times these apps are collecting much more data than you might think, such as contact information for third parties, data from your employees' social media applications, their call and text history. So it really could be a very deep dive into an employee's personal life, which is more than what the employer needs and in many cases is likely entitled to receive from the employee. So before issuing or requiring any sort of contract tracing app policy, we really suggest that you understand what the full scope is here and how closely the purpose of it is tied to your objectives. So if you intend to ask your employee about out-of-work activities related to social distancing or COVID-19 public health orders, please make sure that you connect those inquiries to compliance with relevant public health orders in your jurisdiction. So as Rebecca went over at the beginning of the presentation, there are a lot of different public health orders that may apply to your specific operations. So ensure that you're checking your local guidance and not making inquiries that are beyond the scope of what is and what you're entitled to do so by the public health authorities. In general, those inquiries should be limited to restricted and not diving into protected classifications to the extent that's possible. So, for example, instead of asking an employee if they've attended religious services in person, you can simply just ask them if they've attended large group gatherings, because the same answer would be applicable for both, and in one instance you wouldn't be diving into an employee's personal religious activities outside of work. You should also avoid with any of those surveys implicating the privacy interests of third parties. So for example, limit any questions about your employees' household members, whether they've engaged in activities that could put them at a higher risk of contracting COVID-19. So you can ask them directly, has anyone in your house contracted COVID-19 such that they would be at a higher risk, but avoid asking them details about their household members' personal lives, such as are they going to bars and restaurants.
So just to clarify, with regard to these kinds of surveys, a lot of employers are kind of implementing these surveys to gather information about their employees' compliance with the best practices. Obviously, if you do have people coming into an office, you don't want to bring somebody in there who's been, in large group gatherings constantly for the last couple of weeks, or out in the world doing things that are, not permitted under the local health orders, meaning that they may have COVID-19 and they may be spreading it to others in the workplace. So, we've seen a lot of employers wanting to have employees fill out these surveys, about their compliance with all of the rules that have been put in place. And so these are just guidelines to keep in mind if that's something that you're intending to do.
And here's a sample employee survey, which you all can take a closer look at when you receive the slides. But essentially, you'll see that the questions are pretty broad and don't go into specific details about employees' personal activities and history. So it's, for example, have you checked your temperature today? If so, can you confirm that you don't have a fever above 100.4 degrees? Confirming that you haven't had any of the symptoms that are known to be connected to COVID-19, that they're not currently required to quarantine due to having been in close contact with someone with a known or suspected case of COVID-19, and certifying that they'll wear a cloth face covering at all times in the building. Similarly, here is a survey that has been published by the San Francisco Health Department, which any businesses in San Francisco are required to provide a copy of to their personnel. So this is similarly, the questions are pretty similar to the ones we just went over in the sample survey in the past slide, but the questions are, in the last 10 days, have you been diagnosed with COVID-19 or had a test confirming that you have the virus? Do you live in the same household with, or have you had close contact with anyone who in the past 14 days has been in isolation for COVID-19 or had a test confirming that they had the virus? And then again, certifying that you haven't had any of the symptoms which have been known to be connected to COVID-19. So you can find this handout on the San Francisco Department of Public Health website, and it should be provided to all of the employees if you have employees in San Francisco. So just a reminder about medical records. These must, as all types of medical records, any information that you're receiving regarding an employee's COVID-19 related symptoms or medical information should be stored separately from their standard personnel files, and the access to that information must be limited because they are considered to be confidential medical records. So they can be stored in an employee's existing medical files, and to kind of go back to what we've already covered, so this includes any statement from the employee that he or she has had the disease or suspects that he or she has the disease, and any notes or survey results from questionings given to your employees about their COVID-19 symptoms or related activities. So all those records are considered to be medical records, must be treated with confidence, and should be kept separate from the employee's personnel files in a designated medical file.
Okay.
Now I'll turn it back over to Rebecca.
One last thing before we go into the EEO slides. We have been getting a lot of questions from employers about whether they should develop some kind of a liability waiver that they would have employees sign in order to come back into the office or to come back into the workforce. We have not been advising employers to roll out those types of waivers. Some employers are using them for consumers, which is a different issue. But when it comes to employees, I don't think there's much benefit of rolling out that kind of a liability waiver because the majority of the potential claims that an employee may have against the employer would not be waivable. So the waiver is probably not going to be enforceable. And then, secondly, just considering the kind of morale issues that you might be facing from your workforce if you're having them come back to work and slapping them with this legal document and saying, oh, by the way, I know we're having everybody come back, but please sign a waiver of liability. It's just probably not going to have a positive impact on the workforce. So for those of you who are thinking about it, our advice has been not to use those waivers for employees, but consumers may be a different topic. Okay, so moving on to equal employment opportunity obligations. I think there was maybe a misperception at the beginning of this pandemic among some people that all the rules were off the table now. We're in a new world, everything's changed, everything's crazy, we don't have to follow the old rules. And that's really not true, as demonstrated by the amount of guidance that's been coming out from the EEOC during this period, reaffirming the laws that have already been in place. The same rules basically apply. We just have to think about some of the issues in kind of a new way. So for starters, as probably everyone on this call knows, The pandemic has definitely resulted in an increase in anti-Asian bias and anti-Asian rhetoric, and some pretty terrible instances of people being harassed and mistreated because of this association that people have between the pandemic and Asian countries. In response to that, the EEOC has issued guidance, recommending and stating that this would be a good time for employers to remind all of your managers that they have an obligation to report and address discrimination and harassment, and also to remind workers that discrimination and harassment will not be tolerated in the workplace. So you probably already have existing policies on these topics, but this is a good time to just remind everybody of the rules. As we touched on a little bit earlier, employees with disabilities may be entitled to additional accommodations during the pandemic. So for starters, if you have employees with underlying medical conditions, especially employees with underlying immune conditions or other things that might make them more susceptible to COVID-19, those employees may be entitled to a reasonable accommodation, such as telecommuting or a leave of absence. So, you may have employees bringing in notes from their doctors saying that, they have to work from home or they're not able to commute to work. In those cases, you should follow the same interactive process that you would for any other employee with a disability. One thing that's been kind of interesting is that the EEOC's guidance has specifically identified mental health disabilities in addition to physical disabilities. So employees that, had pre-existing anxiety or PTSD or depression or something like that, the EEOC has specifically acknowledged that the current pandemic may be exacerbating those conditions, making it harder for those employees to come to work or to focus on work. So keep in mind that, it's not just people who have a physical disability. There are mental health disabilities that could be impacted by the pandemic as well. And it doesn't even need to be somebody who had a pre-existing mental health condition. It could be a condition that developed during the pandemic. And in that case, they would still be entitled to the same kind of reasonable accommodation and interactive process that any other employee with disabilities would be entitled to. Complications from COVID-19 may also be considered a disability. So even though COVID-19 is kind of a temporary illness, it's possible, based on a certain employee's symptoms or experience with COVID-19, that it could qualify as a disability and qualify them for some kind of a reasonable accommodation as well. So, if someone has the symptoms, that might be a leave of absence, or it could be working from home. Employers cannot require employees to disclose the existence of a compromised immune system because that would be likely to disclose a disability. So just be kind of careful in terms of the process here. If you have an employee that comes in with a note that says that they have a compromised immune system, recommending that they need some kind of an accommodation, of course, that's all valid. That's part of the interactive process, and that's something that you can, ask for that from them. But you can't go around asking people, do you have an underlying immune condition? How's your immune system? You can't kind of go out affirmatively and make people tell you that information. And then lastly, we touched on this earlier, but if there's an employee that says they're not coming into work because of a government directive, so let's say, the CDC or the local authorities have said that this employee is currently required to self-isolate or self-quarantine or something like that for some reason, if you're terminating that employee because they're not coming in and they're following a government order, it is possible that they would have a wrongful termination claim for that. So as you're thinking about bringing employees back to work, one really important thing is to ensure that those decisions are not being influenced by protected categories. So for example, you couldn't say, you know what, the safest approach is going to be to have only the people without disabilities come back because they are in the best condition to deal with COVID-19. That is not something that would be permissible. Similarly, you couldn't say, we're going to have everyone who's over 65 is going to have to stay home and they can't come back to work, but everybody under 65 can come back to work. These are not decisions that are permissible because they're being made on the basis of a protected category. But there are some considerations related to that to keep in mind. So let's say if you're hiring new employees and you find out that someone who you've given an offer to has tested positive for COVID-19, which means they're not currently safe to come back to work, you can revoke the offer if you can show that the job requires them to start immediately, or you could delay their start date until after they test negative for COVID-19 and have recovered. If you have people that you've been interviewing or people who've maybe been furloughed for a little while and they're coming back, if you have anyone that has a disability, is pregnant, or is over 65, which means that they're in kind of a high-risk group, again, the employer cannot make unilateral decisions based on those protected categories. But if you do have an employee in one of those at-risk groups that raises a concern and says, I would like to not come in, I don't feel comfortable, I don't feel safe, you can offer to them that they delay their start date or delay their return date. But it has to be, something that the employee is actually seeking. It can't be that the employer is just imposing that on somebody. The EEOC guidance has acknowledged that, given the current status where a lot of people are working from home, a lot of companies are having trouble with revenue right now, it's possible that employers may experience more difficulty in providing accommodations. And so some of the challenges that the EEOC has acknowledged is that, it may be difficult to conduct a needs assessment. So if you have an employee that's asking for some kind of special equipment or some kind of ergonomic desk or chair, it just might be harder right now to get an ergonomic specialist to come out and assess that work setup. It may also be difficult to buy equipment, harder to get to stores, could be shortages of equipment, lots of reasons that it might be difficult to get equipment that an employee might need. It could also be difficult to provide temporary accommodations or remove marginal functions. And there are some economic factors that could also help prove undue hardship. So you might have a sudden loss of some or all of the income stream or a reduction in discretionary funds. So, this all goes to whether an accommodation that's being requested by an employee with a disability is something that the employer has to provide. And as you probably all know, under the law, if the employer can prove that the requested accommodation is an undue hardship, they're not required to provide the accommodation. But, all that being said, even though the EEOC has acknowledged these challenges, an undue hardship is still very difficult to prove. So I wouldn't, go jumping at the chance to deny accommodations just yet. If you are considering denying an accommodation on the basis of undue hardship, it's probably something that you'll want to consult with counsel about, just because it can create a lot of legal risk. In addition, for employers that have requirements that employees wear personal protective equipment, there may be additional accommodation obligations. So if you have someone with a disability who is allergic to latex, let's say, you obviously can't require them to wear latex gloves. You may need to provide non-latex gloves. If you have somebody who's hard of hearing and you have interpreters in your workforce, you may need to provide modified face masks so people can read lips. If you have employees that are in wheelchairs, you may have to provide different types of gowns or other personal protective equipment, to accommodate the wheelchair. In addition, religious accommodation obligations remain in effect. So it's possible that some employees may need modified equipment because of their religious garb or because of their religious beliefs. This is an issue, direct threat, which has gotten some attention in the last couple of weeks. The EEOC initially put out some guidance on this. It was apparently misinterpreted, and all these articles came out kind of explaining the new guidance. And then when the EEOC saw what was being written about it, they immediately revoked the guidance and rewrote it, saying that everyone had misunderstood what they were saying. So under the ADA regulations, an employer can exclude someone from the workplace if they're a direct threat, which means that their disability poses a significant risk of substantial harm to themselves or others. And so a lot of employers have been thinking about, in the context of COVID-19, For example, if you have an employee that has a very serious underlying health condition that makes them at added risk of COVID-19, can the employer unilaterally say, it's so dangerous for you to come in here, you have to stay home, you can't come into the office? The EEOC guidance has made very clear that it's a very high standard that has to be satisfied before the employer can unilaterally exclude somebody from the workplace on that basis. And they've also said that it cannot be based solely on the CDC's guidance, saying that a particular condition places the employee at an increased risk. So if you are going to think about whether to exclude someone from the workplace on this basis, there are several factors you'd have to consider. First of all, you need to think about the duration of the risk. You need to think that you need to consider that the nature and the severity of the potential harm to the employee if they do come into the workplace. You have to consider the likelihood of harm, and you have to consider the imminence of harm. And even if you you examine all of these factors and determine that it's really not safe for somebody to come to work, you then also have to conclude that there's no accommodation that could allow that employee to keep working before you can decide to exclude them. So I just want to emphasize, this is a very high standard, very difficult to satisfy. And as with the undue hardship analysis that we just talked about, if you are thinking of unilaterally saying to an employee that they can't come back because of a disability that they have, this is definitely a decision that you should make in consultation with counsel, because it can lead to a lot of risk.
The last topic we're going to go over is some of the employees' various time off options that they have. In light of COVID-19, there have been new federal time off options that have been issued, which we're going to go through in a little bit more detail. So there are many potential sources of employee time off. From a paid time off perspective, there is PTO per your existing PTO policies, which they may have accrued, and accrued sick leave. There's also the Families First Coronavirus Response Act, which is one of those newer time off options, which I just mentioned, which we'll go over in a little bit more detail. And under the Families First Coronavirus Response Act, there is a paid sick leave option, and there's also a paid FMLA leave option. In terms of unpaid options, there is leave as an accommodation or medical leave. There is personal leave of absence accommodations, which you might want to consider. There is FMLA and the California version of FMLA, which is the California Family Rights Act. And there is supplemental income from the state. So there's state disability or unemployment benefits that employees may be entitled to right now. And there's the California Paid Family Leave Act. So for employers that currently have unlimited PTO policies, we have been advising that employers consider updating those policies to address interaction with COVID-19. So for example, employees who are refusing to return to work. There was a recent case in April 2020, McPherson versus EF Intercultural Foundations, which sort of went over this topic. It stated that PTO is not additional wages, but it should be a consideration in terms of employers providing flexibility right now. So as we mentioned earlier in the presentation, the CDC and other guidances have explained that employers need to be more flexible with their time off options right now. So even though PTO shouldn't be considered as additional wages, it should be something that employers are considering offering right now, because it goes to providing flexible time off options and encouraging employees who may be sick or can't return to work to stay home. The case also indicated that you should spell out rights, obligations, and consequences of failure to schedule PTO, allow sufficient opportunity for employees to take time off, and administer PTO policies fairly. So no use it or lose it inequities right now, as that could be discouraging to employees who may eventually have a need to use that PTO because of COVID-19 related reasons.
So one thing I'll add about unlimited PTO policies, for a long time, this has been kind of the trend that a lot of employers have been adopting is, implementing these new policies of unlimited PTO, where employees don't actually accrue any PTO, but they just can use it whenever they want to. And a lot of employers thought this was really great because you could avoid cashing out PTO upon termination because an employee didn't actually accrue any PTO. So it was kind of a cost savings that many employers thought that was a great benefit. We've been advising against unlimited PTO policies for a while, and one of the reasons is that it becomes really challenging to administer other types of leave when you have an unlimited PTO policy. So for example, under FMLA or other types of unpaid leaves for medical reasons, typically when employees are taking FMLA leave or taking time off for a long-term medical issue, that would be unpaid leave. But if you can show that other employees have been allowed to take paid time off, for personal purposes or vacation or other things in similar quantities of time, it becomes difficult to justify that discrepancy. Why are you making people with medical conditions take unpaid leave when you're letting people take similar amounts of time off paid to go on vacation? So it just becomes very challenging to manage all the different types of employee time off when you have an unlimited PTO policy. So that being said, if you do have a policy like that, you need to make sure that you really carefully think through all of the other different types of leave that you're offering, how those will interact with the unlimited PTO policy, and then you make sure that the unlimited PTO policy contains all of these requirements that are listed on the slide that were mentioned in the case that's here. In that case, the court actually found that the employer did not really have an unlimited PTO policy and determined that even though they claimed to have had an unlimited PTO policy, it seemed like, in fact, employees were really limited in their use of PTO, and the employer did have to cash out PTO to them as a result of the lawsuit. So it's not a totally risk-free scenario. You'll have to be very careful.
So the Families First Coronavirus Response Act is a new federal paid leave act, which applies to all employers with less than 500 employees. If you have anywhere from 1 employee to 499 employees, this applies to you. And it's in effect until the end of this year. So there is a hardship exemption for businesses with less than 50 employees, so not quite 1 to 49, but that 1 to 499, but that is subject to certain criteria. There are refundable tax credits to cover costs, which can be advanced to employers. And this act basically provides emergency paid sick leave and emergency paid FMLA leave, which we'll go over in the next slide, for employees who are taking time off for reasons related to coronavirus. Employers are required to provide notice to their employees about the Families First Coronavirus Response Act, and you can find guidance on that notice requirement on the DOL website. So the emergency paid sick leave is 80 hours of paid sick leave at employees' regular rate, which you average out over what their regular rate has been over the last 6 months. This includes overtime, but that overtime is capped at 80 hours. This applies wherever an employee is unable to work or telework because of a quarantine or isolation order from medical authorities or the government. It also could apply if they're experiencing COVID-19 symptoms and seeking a diagnosis for COVID-19. It could also apply if they're caring for someone who's subject to quarantine or under an isolation order. And it could also, which is sort of unique and surprised a lot of people when this first came out, apply if employees are caring for a child whose school or place of care is closed. So there are some payment caps in terms of how much employers are required to pay out to their employees who are exercising emergency paid sick leave. For caring for self, they're entitled to up to $511 a day. That's the maximum. So they should be paid their regular rate if it's less than that, which is an aggregate amount of $5,110. If they're caring for others, it's less than that. So it's 2/3 of their regular rate, and it's a maximum of $200 a day, which totals $2,000 over the entire period. So the Families First Coronavirus Response Act also has an emergency paid FMLA leave option. So this is for all employees who've worked for the employer for more than 30 days. They're eligible to exercise this leave option. It provides 12 weeks of job-protected FMLA leave for employees to care for a child whose school or place of care is closed to COVID-19 related reasons. The first 2 weeks of the leave are unpaid, although employees can use PTO or accrued sick leave that they may have. And the remaining 10 weeks are paid at 2/3 of the regular rate, so that is up to $200 a day, a $12,000 aggregate amount. And similar to the previous slide, overtime is included in this pay calculation for emergency paid FMLA leave.
So one major distinction that I just want to emphasize is that whereas the paid sick leave has a variety of different purposes, which includes caring for yourself, or if you have been diagnosed with COVID, or you're caring for someone who's been diagnosed with COVID, this emergency paid FMLA leave is only for employees who are unable to work because they're caring for a child whose school or place of care is closed. So it doesn't matter if they're still caring for somebody with COVID or they have COVID that goes on beyond 2 weeks. This leave is only for the child care portion. So that's kind of an interesting aspect of this new law, and kind of says a little bit about what the priorities were when it was being drafted. But the other paid sick leave is the one with the more expansive reasons that could provide a qualifying justification for the leave.
So the Department of Labor has issued some additional guidance on the Families First Coronavirus Response Act. Employers with less than 50 employees who are seeking a hardship exemption should be internally documenting why providing the child care leave would jeopardize the business. So you should be carefully keeping track of why you think it poses an undue hardship to your business to allow those employees to take the emergency leave. The DOL has also indicated that both types of leave may be taken intermittently. So that means they don't have to take the full 80 hours all at once. They can take a portion at one point and a portion at another point when the employer allows it. So the DOL does encourage arrangements which combine telework and intermittent leave. So if the employee can work remote for some amount of time, but then needs to take emergency leave to care for child for the other portion of the time, that is something that is currently being encouraged by the DOL. Employees who are currently furloughed are not entitled to paid leave, and this new federal paid leave is in addition to leave that's already provided by the employer. So this doesn't take the place of their accrued PTO or accrued sick leave. This would be in addition to that.
Yeah, so one point of clarification, the employer actually has to have work for the employee to do in order for them to qualify for this leave. So as Jaya just mentioned, if someone is furloughed or they're on a leave of absence because there just isn't work for them to do, or they've been laid off, they don't get to invoke this leave and then make the time off paid. So they have to actually have work to do and be unable to do it because of a qualifying reason. As Jaya mentioned with the intermittent leave, we've definitely been encouraging that. We're seeing a lot of situations where we have, parents of young children who are working from home. They're having a hard time working their full 8-hour schedule because they're responsible for childcare for some portion of the day or all of the day, and they're only able to work during periods when a partner or a spouse is watching children, or after the children go to bed, or things like that. And so in those situations, we've been encouraging clients to allow the employees to take the intermittent leave, during the periods when they're caring for a child and aren't able to do their work, and then to do their work during the other hours when they're able to do things during the day. And the reason for that is, as Jaya mentioned, there are refundable tax credits to cover the cost of the leave. So, the employees are able to still get paid for the time, even if it's at a reduced amount, the 2/3, or, even if the cap is below their normal pay, at least they're still getting paid for times when they're not able to work. And then the employer gets reimbursed by the government through these tax credits. So that's what we've been advising if you have employees in that situation who are, only intermittently able to work because of these childcare obligations.
So in California, Governor Newsom issued an executive order which waives the usual 1-week waiting period for employees who are disabled as a result of COVID-19. So employees who are disabled due to COVID-19 can immediately apply for disability-related benefits. The Employment Development Department is taking state disability insurance claims filed by employees who cannot work due to having or being exposed to COVID-19 when it's certified by a medical professional. And older employees who are an age-defined vulnerable population and who obtain medical certification of their age-related condition as qualifying as an illness can also be eligible for those disability benefits.
So I think the advice here is that if you have employees who are not able to work because of a disability or because of COVID-19 or exposure or something like that, given all of the enhanced unemployment benefits that are currently being offered and the increased eligibility that's out there, we've just been encouraging employers to give employees information about how they can apply for those benefits. Obviously, as an employer, you can't guarantee that someone is going to be eligible because the state makes that determination. So we wouldn't want to make any promises, but at least giving employees information about potential eligibility, allowing them to go apply for those benefits that the state is currently offering, just to offset any kind of lost income they might be having due to a disability, an illness, or anything like that.
So there's also the California Paid Family Leave Act, which is always in effect. So this provides partial wage replacement benefits. It allows employees who take time off to care for a family member to receive those wage benefits. So this could be a child, a parent-in-law, a grandparent, a grandchild, a sibling, a spouse, or a registered domestic partner. So it's not just everyone, but it is fairly broad in terms of the family members who may apply. It also could cover new child bonding. So these benefits include up to 6 weeks of paid family leave with payment of approximately 60 to 70% of wages. And it's capped at a maximum of $1,300 per week for up to an entire year or 52 weeks. And those wages are tax exempt, like Rebecca mentioned, was one of the prior leave options. Employers will be required to, or will be entitled to, obtain tax benefits for paying employees for this time off. The California Paid Family Leave Act does not, unlike the FMLA, provide job protection. So they will still have to look at CFRA or FMLA in order to take a leave that is protected. The minimum number of employees in order for an employer to be required to offer this is 50 employees. And employees may apply for paid family leave if they're caring for an ill or quarantined family member with COVID-19, but here it must be certified by a medical professional. So in addition to some of those federal and state leave options, there are also sick leave ordinances that have been issued by local authorities. So here we have LA and San Francisco. So in LA, employers who have more than 500 employees or 2,000 employees nationwide must also currently provide an additional 2 weeks of paid sick leave to employees who are unable to work due to COVID-19 related reasons. And they may not require a doctor's note in order for the employees to take that leave. In San Francisco, employers who are covered by San Francisco's paid sick leave ordinance must also allow employees to use their accrued paid sick leave for various COVID-19 related reasons. And similar to LA, they cannot require a doctor's note during the duration of the COVID-19 public health emergency, which we're still currently in. So here we've included links to some additional employer guidance, which you all should take a look at. As Rebecca has mentioned, and as I've mentioned, there's a lot to keep in mind here for employers, and it can be difficult to kind of keep track of everything. In some cases, it may seem like the guidance is contradictory. And when that happens, you should always take the most conservative approach. So we really encourage you to take a careful look at some of this guidance. And of course, you can always reach out if you have questions.
All right, so that concludes the presentation that we have planned, and